in the matter of EI and the Secretary of State for the Home Department.
Yes, Ms. Warren.
My lords, my lady, do you mind, we have rather come forward, given that there's no
Don't worry at all, that's fine.
counsel in this matter. If I could move straight to opening the case, I appear for the appellant, and my learned friend, Miss Jones, appears for the dependent, the Secretary of State for the Home Department. The decision, which is the basis of this appeal, appears at page 59 of the main bundle. It is the decision of Deputy Upper Tribunal Judge Hanbury from the 4th of December 2023. The background to this decision is that there was an appeal to the First Tier Tribunal by the appellant, which was successful on protection grounds and in consideration of her human rights. Her credibility of her account was accepted there by Judge of the First Tier Tribunal Holt, and his determination appears at page 87 of the main bundle.
Yes, I mean, we have obviously read the papers, so if there's particular points you want to draw our attention to, please do, but don't feel obliged just to tell us the history for the sake of it. No.
No, that's fine. Moving on then, it will be clear to your lordships that the appeal grounds that form the basis of this appeal were or encompass those that formed the basis of the appeal to the upper tribunal. So the question of particular social group and the engagement of the Refugee Convention, risk on return and humanitarian protection. But in addition, further grounds are contemplated, including Article 8, risk on return and humanitarian protection. I'm proposing to take the 6 grounds that form the basis of this appeal in turn.
Is that, or do them any way you want, but can I just get clear in my own head what the relationship between them is? The first 5 are threat-based.
That's correct, yes.
And it really doesn't matter much to your client whether, obviously we got right, but if you succeed, whether it is refugee status or humanitarian protection. And subject to one point, the same issues come up on both. Oh, annoyingly, we haven't been given the relevant rules about humanitarian protection. Are they? You didn't bring them with you.
I apologise, I didn't.
Where am I right in thinking that? What's the legislative basis of humanitarian protection at the moment?
It is laid out within the immigration rules.
I see. So what's happened to the qualification directive? That went at Brexit, did it?
I think I'm going to have to check before I give an answer to that one.
Ms. Jones, what's the formal? There used to be the qualification directive and regulations based on it, which covered both refugee status and humanitarian protection in a single code.
Yes.
And I just don't know what happened to those. Do you?
Yes, the qualification directive was directly effective, but it was also incorporated into domestic law via the immigration rules.
Yeah.
So the 2 categories remain within the immigration rules, but the direction is no longer.
But there weren't. Well, I thought there were some regulations as well.
There were, in addition, some regulations, but they mirrored the immigration rules.
But I just want to be accurate about this. Insofar as there's a claim under humanitarian protection, what is the governing legislation, using legislation in a broad term?
It's the statutory instrument of the immigration rules under the Immigration Act 1971, which empowers the Secretary of State.
Yes, I see. So it is the immigration rules. So whatever
is.
regulations there were, they're out of the picture, and we're out of the picture at the time of the relevant decision.
They were, yes. And
Yes, okay,
both
no,
times.
that's all I need to know. And I just did a printout, but it's funny enough, you can't get the immigration rules on the internet anymore. You only get the guidance. Bizarre, isn't it? Or you probably can, but you can't get on a Google search. You have to know where to look. Don't worry. But the point I'm trying to get at is I haven't got an up-to-date version of the immigration rules. But the version I looked at, which was the only one I could easily get hold of, which is from 2022, it was 339C, and then lots of sub-rules. Are those the right paragraphs?
Yes, they are, and I don't recall any significant change in that section of humanitarian protection and asylum in relation to this.
For good order's sake, could someone over the German, if we get there, you may all be very succinct, just get us the version of the immigration rules applicable to the decision in question? Because
yes,
and it may be absolutely dead easy, but I don't think it's set out anywhere in the authorities bundle or when you're studying arguments.
No, I have the Right Archive version open.
Splendid.
So I can link it to it, and we can try to get it printed over lunchtime, if that would assist your lordships.
Well, it's just so that we have it, because it's so easy. They change from time to time. You may be right; they haven't changed. So we've got to have the firm legislative basis, so we're using the right words. Nicholas,
Yes.
could you probably print it? Yeah. Send it to our clerk. Yes, I was. My lord suggests that the sensible course is just to send it to our clerks. I think you'll have their email addresses.
I think her ladyship's clerk.
One is
emailed
good
us
enough.
about
Then
contact
she'll
forms,
circulate
so I
it to the rest.
That's fine if it could come to my clerk. Yeah.
That's very helpful.
I shall do, although they're now up to about sort of 1,500 pages, so your lordship might not want all of it printed.
Well, I think we only want, we won't print it, I'll ask them for it to be printed, but once we got it on our screens, and if we want to print a particular page, we can do that for ourselves.
Thank you.
We're that good. Right, thank you. I'm sorry, Ms. Warren. I just wanted to make sure we were
Yes.
we knew the formal basis. The point I was putting to you was that it doesn't make much substantive difference if you're not on your case. There are threats. There's still a risk. There's no possibility of internal relocation. There is insufficiency of protection.
Yes.
All those are relevant considerations, whether it's refugee status or humanitarian protection. The only difference is you have an extra hurdle for refugee status, which is showing membership of a particular social group.
Yes.
Is that right? I don't want to oversimplify.
No, I think that's correct. And I think indeed nowadays there's no practical difference for the person who receives a grant of humanitarian.
Sorry, I didn't hear what you said.
No practical advantage, if I could put it like that, to a grant of refugee status rather than humanitarian protection.
Well, the only reason I was dealing with this now is you were saying you were going to start straight away with a particular social group, and that's fine. If that's how you prepared it, we'll have to look at it at some point anyway. But in a sense, that's not really... That's almost the least important point in the threat part of the case. You can lose on that. If you win on everything else, you're fine.
Yes, that's
But
absolutely
if you're
right.
prepared to do that first, fine.
I'll be guided by your lordship.
Well,
I think then...
Well, I'm not going to guide you, but you have seen the position taken by the respondent, which is that most of these nice points about internal relocation, sufficiency of protection, and indeed particular social groups simply don't arise because the upper tribunal judge found that there was no threat.
Yes, okay.
And that's obviously the overriding point you've got to take on, but up to you whether you take it on first.
I think then that I will consider grounds 2 and 3,
Okay.
which deal directly with the question of risk on return.
Yes.
Or this has been put
If
in
you're happy with doing that, that's fine. Thank
as
you.
threat. The Secretary of State have said that the question of risk on return is not challenged by the appellant. And it'd be my submission that that's just plainly incorrect. Grounds 2 and 3 are both directed to the question of the risk of return as found by the judge.
I'm sure you're right, but let's just look at them.
Yeah.
Yes, well, ground 2, as pleaded, is just very general, says humanitarian. It doesn't say what aspect of his decision was unlawful, but you say that covers risk on return. And then 3 is a specific point about relevance of accepted serious past persecution. And when you say those two together show that you are challenging his finding on risk on return.
Yes. Yes. If I could deal then with ground 2, and the question there is, how far was the judge entitled to consider the question of risk of return at all, given that the first tier judge in his determination at paragraph 28 had made a finding that there was a serious risk to the appellant. That's at page 98 of the core bundle.
Give us a moment. Well, yes, we see what he says. What's your submission?
I think it's a female judge.
Yes, I thought it was too.
In an FTT, isn't it?
I apologise. I don't know personally.
Well, I think she's referred to. I
First-tier
was
judge
too coy, unlike my lord. I thought you knew better, but you weren't there either.
No, I wasn't. I apologise.
I think the upper tribunal judge refers to the FTT judge as she.
She, at paragraph 28, says, on the basis of my findings of fact, it appears that the appellant will be at risk of serious harm, and her personal circumstances are such that it would inhibit her relocation. This wasn't challenged by the Secretary of State in their grounds of appeal to the upper
Is that right?
tribunal.
It doesn't.
They
You must
appear-
show us that. I'll tell you what, just so you know what you're meeting. I understood the upper tribunal to be preserving the findings of primary fact.
Yes.
That is, that she was assaulted and indeed ultimately raped,
Yes,
and that is accepted.
yes,
But he was not accepting the conclusion about risk drawn from that. And that they are very different things. The basic point being that happened 6 years ago, and the judge finds there's no reason to believe that the risk is still present if she returns 6 years later.
Well, if one looks at the error of law hearing,
Yeah.
which appears at page 74, but the relevant part of the judge's reasoning is at page 77.
Yes.
He deals with 4 issues, and that was the 4 issues that were put forward by the Secretary of State in their grounds of appeal. So the first of those was whether the Refugee Convention was engaged on the basis of a particular social group.
Sorry, where are you reading from?
It's page
I see. Yes, I see.
There were 2 hearings in front of the upper tribunal.
No, I know that. I'm just.
So which paragraph do
I
you
just
say
want-
deals with
Page 15 at the top of page
paragraph
77.
15? Thank you.
Yes, I see. The 4 points aren't set out as 4 points, but you mean there are 4 points there?
Yes, and they correlate to the 4 points that were put forward by the Secretary of State in their
Give us
grounds.
the
Page,
page reference for the Secretary of State's grounds.
page 84.
Well, there appear to be more than 4 matters there.
I don't think they easily. I don't think it's each paragraph is each ground.
They're all right, but I don't mind. You said 4 as if that was a sort of established.
Well,
point.
I think it is because the first one is the engagement of the Refugee Convention.
Yeah.
The second one is the approach to credibility, and then from 1G, sufficiency of protection, and
Well, look, don't worry. Let's look at
internal
what he actually found at the. We can do that exercise for ourselves later if we want to.
yes,
But let's look at what was found at the error of law hearing.
Yes. In some ways, it was unclear, I think, what precisely was being preserved from the First Tier Tribunal. Paragraph 15 deals with the particular social group membership. 16 is directed to sufficiency of protection. 17 is the connected issue of internal relocation. And 19 deals with the approach to the appellant's credibility, which was accepted. So there wasn't.
So where do you find him accepting that there was that he was at risk on return?
Well, he doesn't accept it, but he doesn't dispute it either. It appears to be those four issues, discrete issues in some ways in relation to the question of risk, and that they can all be hived off on that and still affect the outcome of the appeal. But risk was not part of the Secretary of State's appeal to the upper tribunal, and it wasn't considered by the upper tribunal.
Okay, well then perhaps we ought then just, having said that we wouldn't do it now, let's just quickly look at the Secretary of State's grounds. 84.
84, yes. So
just give me a second just to read through them. So is A and B, as you say, appear to be about a particular social group. And indeed C. D goes to whether there is a fear, and therefore whether there's a risk.
I thought B and C also do, although it's tied to the Refugee Convention.
My lord may be right. I had understood that saying that if there is a fear, it doesn't engage the Refugee Convention. But
and D, I would suggest ties the question of risk directly to inconsistencies in the appellant's accounts, which we know that the upper tribunal judge rejected that challenge in the error of law hearing.
Can I just take it from the top? On page 77 is what I see at paragraphs 15, 16, 17, 18 and 19. The four flaws which the upper tribunal judge identifies with the first tier tribunal decision.
Yes.
The errors of law.
Yes.
Says these are under-reasoned or not explained or whatever. And so then he...
Although the last one wasn't found to be an error of law.
Although, no, there was a sort of question, lack of sufficient reasons. The judge may not have given sufficient reasons for finding the appellant was credible. So that one's left as a sort of semi-open door.
It is not the most generous allowing of the acceptance of the appellant's credibility.
What was decided.
Yeah.
But I take the point on credibility. It's a bit unclear. So then the decision is at paragraph 20.
Yes.
The judge made a material error of law, pausing there in at least the three ways at 15, 16 and 17 above.
Yes.
So that's home, and that's what's decided. And then the judge goes on to say fact findings remain, but retake the decision with the basis of updating evidence. And the only sensible way of reading that, and I think the way my lord has suggested that needs to be read, is to say the primary fact findings remain, but at least in these above three contexts, the evaluative decision needs to be retaken.
Well, I would say those three, as I've said, discrete areas need to be reheard and were reheard. But the question of humanitarian protection wasn't challenged and was directly related to the preservations of the primary findings of fact.
But sounds very odd. Why would the Secretary of State be worrying about whether there's refugee or humanitarian protection? Clearly, it must have been challenging humanitarian protection.
I can't speak for them. May have been that they thought it was unchallengeable, may have been oversight.
But look at the practical
Am I-
situation. If we put ourselves in the position of your client before the upper tribunal, then if what you say is right, then she could simply have said, well, I don't mind. I've achieved what I want because there's no appeal against what I need. All the other things are peripheral. That's not what happened. But it went ahead, in effect, on the basis of a much more general challenge, including to the assessment of risk. That seems to be what was
Well, I
happening.
think.
Otherwise, the hearing would have been unnecessary.
Well, of course, once there's an appeal in process, the appellant can't or would be in some danger to rest on her laurels and not meet that appeal.
No, but and the point I'm making is that the representative of your client at that hearing didn't simply say, well, why are we here? Because we already have preserved findings which are all I need.
Well,
Indeed, that was you, I think.
yes, this is the point I come in.
Yeah,
And I think I did make that point.
Well, hang on. Just before one more thing we can feed in. I'm looking at your skeleton argument for the remaking hearing,
Yes.
the second hearing, which starts at page 4 in the supplementary bundle.
Yes,
Rather confusingly, it says at the top, in the First Tier Tribunal.
I apologise.
But that's a typo because it clearly is in the upper tribunal if one looks at the substance. And then over the page, the issues, you write, following the decision of Deputy Upper Tribunal Judge Hanbury, promulgated on the 15th of August 2023, the following issues remain to be decided. 1, whether the appellant's a member of a particular social group. 2, whether the appellant would face a real risk of persecution, serious harm. Well, that's how it seemed to us, and it seems to be how it seemed to you as well.
Well, then I answered that question at paragraph 15 of the skeleton argument.
Which page? Where are we? Page?
It's page 8 of the supplementary bundle.
Well, why did you say it was? It's very odd. I'm not getting at you, so I don't understand it. There wasn't an issue. You said the following issues remain to be decided.
Well, it was really to protect my client's position that I felt we had to address that and make the point that there was a finding of serious risk in any event.
Yes, I see. So even if there was some misunderstanding, you addressed the point about whether there was a serious risk.
Yes, to say, well, in any event, as you say, it doesn't matter about refugee protection grounds, if I could put it in those terms.
Sorry.
Of course, it matters, but it doesn't matter in terms of protection because there is this finding that humanitarian protection.
I'm sorry, I've misunderstood this. Para 15 is saying the point I made to you earlier that particular social group doesn't ultimately matter because humanitarian protection is good enough.
Yes.
But you go, I see at 15 you do go further. You don't just say this really doesn't matter because I ought still to win on humanitarian protection. You actually say that the First Tier Tribunal judge found that the appellant was at risk of serious harm.
Yes.
But did they? Did she?
Well, I think it stated in.
Oh, sorry, you're right. She did, but was that unchallenged? That's the real point.
Well, it hasn't been. We've taken. We've gone through the points where it could have been challenged, i.e., the Secretary of State's grounds to the upper tribunal. It could have been raised at the error of law hearing. It wasn't raised. It appears. It certainly doesn't form any part of the judge's reasoning at the error of law hearing.
Okay, well, I see how you put it. Thank you. Let me just make a note of that.
So you say, sorry, I'm trying to catch up. You say paragraph 28 of the First Tier Tribunal has never been subject to challenge, and it sounds good before us. Is that your submission?
Yes. And it is squarely going further because I think it is relevant. It is squarely found that humanitarian protection, serious risk, is made out because the appellant's account has been accepted.
That's what the FTT says.
Yes, But that's also what the judge said. There may have been some ambiguity to approach to credibility, but ultimately he didn't disturb any credibility findings in the first.
Of course, that's right. But the issues to which credibility is relevant is her factual account of things that happened to her.
Yes.
The question of whether there's a threat 6 years later is not something on which evidence from her is as such relevant. Certainly no question of credibility arises. It's a question of evaluation for the tribunal whether this past history means that there is a present risk. And that's got nothing to do with credibility. So preserving the findings of credibility doesn't advance the argument at all.
But it's risk at the time of the hearing that is relevant and has to be considered. So at the time of the First Tier Tribunal, the judge's finding was that there was serious risk. If that was not challenged, it doesn't matter now if it's 5, 6, 7 years later when an appeal then comes to look at those issues.
No, but the hearing was 5 years later as well.
Yes.
So the FTT's statement in para 28 that it follows from the findings of primary fact that there is a risk is also, that's not based on credibility. Well, the first stage of the argument is based on credibility. I find these things happened to you 5 years ago.
Yes.
But the second point is simply an evaluation.
No, the judge is considering the appellant's account in light of all of the evidence in that appeal and finding, yes, given what you've said and I have accepted about your account of harm, then I find that there is a serious risk there.
Yes, what's he doing? He's finding that you suffered this harm 5 years ago. That by itself doesn't answer the question whether there's a present risk. That second question, which is the determinative question, is an exercise in evaluation, not in credibility.
Yes, but the judge clearly makes that evaluative exercise.
In that single sentence in para 28.
Yes.
Is there anywhere else where she does a reasoning process and says a risk of this kind would still be present 5 years later because X, Y, or Z?
No.
No. Okay.
At the date of that hearing, she made the evaluative.
Yeah, of course, but I don't understand what your point is about the date of the hearing. It's obviously at the date of the hearing. And strictly speaking, for the upper tribunal judge, it's the date of the hearing in front of him, because he's doing a remaking. But since the evidence wasn't any different, and the difference in time was only a few months, it really doesn't matter.
If it had been before the judge, yes, he would have had to remake that and come to his own evaluative judgment.
Yes.
I think the point I'm making is that it wasn't before the upper tribunal.
No, I get that point. I just don't think I need added by saying at the time of the hearing, because that's obviously right, but doesn't really advance the argument. Okay, well, I certainly understand the point.
Yes. And in any event, it is a marker where the gravity of harm to the appellant lies, given that there was acceptance of the primary fact and First Tier Tribunal Judge Holt had found that those amounted to a serious risk of harm. And I say that marker lies there because it goes on to my latest submissions that was something that the judge had to and didn't come to consider when he considered or made his judgment of risk to the appellant. I think I should also mention what Deputy Upper Tribunal Judge Hanbury says at paragraph 34 about humanitarian protection, because it is limited. It doesn't accord with what was in front of him, as we've already seen. He makes the point that paragraph 11 of Counsel Skeleton.
Where are you?
It's going to now the primary
Second
decision
UCJ.
under, yes.
Yeah, thank you.
Which paragraph?
44.
24.
Sorry, 34, which appears at page 69.
Yep.
This is his only reference to humanitarian protection.
Sorry, can I just be clear about this? This is one of the many things that puzzle me. Why is he referring to the qualification directive?
I don't know.
He's just wrong. Sorry, Ms. Jones. Maybe you
It
seem
might
to be
be
on top of
something
it.
of a leftover
Yeah. Okay.
in his mind, but they're the same tests, really. So
No, fine, but I've just it's this that puzzled me as to what the everyone agrees it's just it's 339C of the rules.
Yes, but it is possibly arguable that she came within the grace period of the qualification directive given when she claimed asylum because of the withdrawal agreement, but it doesn't really.
Perhaps we can ask Ms. Warren.
So
I'm sorry.
We're talking about humanitarian protection, however it comes about,
Yes,
immigration
and-
rules or qualification directive or whatever. That's the
Yes,
subject.
and although it's possible the qualification directive might apply because of the withdrawal
wouldn't make any
agreement,
difference
it
if
doesn't
it
matter.
did. Yes. Was this explored in front of the judge at all?
It wasn't.
No, so it's just the judge. The judge just thought that was the label he had on it in his mind. Okay, we've got to the bottom of that.
Yeah.
Do you mind just approaching this a little bit more slowly? As this is in this judgment, we've looked, have we, at paragraph 25 already of this judgment, the second judgment, which is now under appeal. Paragraph 25 on page 67. Because I'm not sure how this fits with. I mean, the first issue that you've raised is whether the evaluation of serious harm was even open to the upper tribunal. That's what we've been talking about, as I understand it. How does that fit with the issues identified in paragraph 25 by the judge?
What the issues that the judge says he has to
Yes, I
determine?
mean, it's just, I mean, without being pernickety about going through them one by one,
Yes.
the flavour of those as a whole makes it look as if at least the judge thought that it was open to him to consider on the basis effectively of the primary facts, because that he puts into the first paragraph
Yes.
the extent to which he could, but he doesn't depart from them. What was the risk? And that underlay both the Refugee Convention and the humanitarian protection limbs of the argument.
Yes.
So it sounds as if you happen to be right about the fact that this was never in front of the judge, it's a point that he didn't grasp.
Yes, I think that has to be right. Although it appears in my Skeleton argument, but it is clear from what is said at paragraph 34 that he is failed to grasp the point being made there. Yes.
Anyhow, that and I'm sorry I interrupted you, but you'd already dealt with, but I haven't reached the paragraph that you wanted to go on to, which one? Was it paragraph 34?
Yes.
So is it your case now before us that humanitarian protection was everything? It really was your case, because if you lost on the Refugee Convention for one or other of the technical points, you were still going to maintain, in the face of the finding of paragraph 28, that you're entitled to humanitarian protection.
Yes, this was not something which had been challenged in the appeal, so it was certainly our position there that we were that unchallenged finding would remain.
The unchallenged finding of serious harm.
Yes, and
But
relating to the humanitarian protection.
Yeah, but still for the judge to decide whether that serious harm, I think, warranted humanitarian protection. That's the one doesn't necessarily follow, does it?
Certainly, in the arguments made, it would have followed because there was no basis of challenge to the.
Can we just be very careful we don't lose the thread? Serious harm? You mean risk of serious harm?
Yes.
And does sufficiency of protection, and forgive me if I'm just asking stupid
No.
questions, but does sufficiency of protection and the possibility of internal relocation not deal with identified risk of serious harm, regardless of whether you're under the Refugee Convention or not? Excuse me. Track you're on.
No, I don't think they're an answer to it. I think they also, I think they are discrete issues, although of course they touch upon the nexus of serious harm, but they have to be, all of those issues have to be determined for a protection grant
Yes, but
to be made.
sorry,
No,
if let's just take this paragraph 28 position as our stake in the ground, that there is a determined risk of future serious harm by the FTTJ, and let's just accept for the moment that that wasn't challenged, so you can still hold on to that here. But you still have to ask whether there are, for example, sufficient state authorities to deal with complaints of harm or threat or challenge or whatever, and so you have to look at the availability of police protection, for example. Doesn't that all go to the same point in a real world?
Well, I think what the judge could have found is that, yes, there is a serious risk of harm on return, but that would be ameliorated by the fact that there was sufficiency of protection for the
well,
authority.
eliminate.
Or an
But
internal.
my lady's point is surely right, that they are all just aspects of the ultimate question: is there a risk of serious harm? One question is: are there people out there who'd like to do serious harm? But if there are, but the police will protect you, then there is no risk of serious harm.
Yes.
Or if you could go somewhere where they couldn't find you.
Yes.
So they are sub-questions that arise under the ultimate question is, are you at risk of serious harm?
I think it is put that the questions have to be determined, each and every one of them, and they are. You could find that there was a serious risk of harm on return, but nevertheless there was serious sufficiency of protection.
Well, that's loose language, isn't it?
No.
If there is sufficient protection, how can there be a risk of serious harm? What you're talking about is there's a risk of people who would like to do you serious harm, but will be prevented by the fact that the police will protect you.
Yes, but the serious risk still has to be addressed.
But it isn't a serious risk if you're going to be protected.
Yes, but
anyway, perhaps we're just talking about words, but
I think there's two issues. I think it's. I think that both determinations have to be made. So one's confined. There is a serious risk of harm, but there is a possibility of internal relocation. The question then is a grant of protection, either refugee or humanitarian protection, follows from that risk of serious harm. If there's an internal relocation option, then the answer is no. If there's
a sufficiency of state protection,
or there is a sufficiency of state protection. So it's not circular in that you don't then say, so there is a risk of serious harm. So you say whether there would or would not be a grant of humanitarian protection. And I think
so. Paragraph 28. I'm just trying to get my head around it.
Yes.
The furthest you can go is to say the judge made primary findings of fact, and his evaluation was that based on what she'd experienced in the past, she had a logical basis for fearing what was going to happen in the future. She had a fear, and you might even go further and say that was an objectively well-founded fear, which deals with the Secretary of State's point. But you still have to say, well, what did the judge say about that? And did the judge then find there was sufficiency of protection? Yes, he did. Did he find there was an internal location, an internal flight alternative? Yes, he did.
Yes.
So doesn't that deal with that point?
No, because it still has to, this question of serious risk still has to be addressed.
Could we look at paragraphs 32 leading into paragraphs 35 and 36, because it seems to me that this is where the judge, in his own way, deals with the issues that he raised at paragraph 25. At paragraph 32, he expresses some scepticism about the disgruntled customers, but says he'll deal with it below. That's 32. Then if we go on to what he now asks as the fifth question, which is Article 3, which is very much in the territory of risk of serious harm, at paragraphs 35 and 36, leading to the second sentence of paragraph 36, in which he takes off from the blood feud issue, but he appears to be finding, whether or not it's to do with the blood feud issue, that the appellant is not at risk of serious harm on return. Now, of course, there may be some confusions in the way that all these issues have been dealt with, but I had understood the judge's assessment as being in disagreement with paragraph 28 of the First Tier Tribunal, on the basis that there were matters referred to in paragraph 32, 35 and 36 that led him to feel that this was not a serious harm case. Is that a misreading of the judgment?
No, I think that is what the judge, I mean, that is undoubtedly the conclusion the judge came to. I suppose the question was he entitled to come to that conclusion?
Yes, but that's an argument not based upon whether it was before him. That's an argument based upon whether he reached a rational decision based upon the information on the remaking of the decision. I mean, we're having to separate out what he was entitled to ask himself with the quality of his answers. Those are two different matters, of course.
And I understood your point to be the first, that irrespective of the quality of his reasoning, if he was allowed to ask the question, he wasn't allowed to ask the question because it's already been decided below and been preserved.
Yes, that's correct.
Yes.
Well, that's what you say, and
I didn't understand those.
Yes, I was
points to be in
taking you to
opposition.
these because I'd understood you to be saying he didn't really deal with it at all. It wasn't.
I see.
And it seemed to me it was fair to put to you that he was actually dealing with it here, but you don't agree with what he
I
said.
see. Yes.
He was dealing with the core of the question of risk as he saw it,
Yes.
but he wasn't addressing himself to how to treat that finding by the First Tier.
Could we be clear about this? You have made a point which I think we've probably explored as far as we can about whether the point was before him at all,
Yes.
and you submit it wasn't for the reasons you've shown us, but you accept that he did in fact purport to decide it, and without prejudice to your argument, he wasn't entitled to. Do you have a distinct challenge to his reasoning on that, or does everything turn on the first point?
No, I do have a distinct challenge. The first point is in the narrow sense to what his reasoning about humanitarian protection, which appears to be wrong or not to have grasped the point that was in front of him. But second, as to the substance of the risk of return, that underlies ground three. So I'll move on to that, if I may, in a moment. I could deal with the rest of the challenging ground two shortly. He makes reference to an argument that he says is raised in Counsel Skeleton at paragraph 11 about humanitarian protection and whether the appellant is entitled to it. My submission is...
Sorry, paragraph 11 of the judgment.
He refers in his paragraph 34...
Oh, I see, sorry.
In his remaking decision. I note that Miss Warren touches on it in paragraph 11 of her skeleton argument.
Can we just look see what he's referring to? So that's in the supplementary bundle at
Page 7.
Page 7.
It's the bottom paragraph.
Was he identifying the right paragraph in
No,
your skeleton argument? I couldn't really...
That argument was not raised. I don't want to give evidence, but I think it's plain from the skeleton. That argument was not raised by me. That question was not raised by me. And it's not referred to at that paragraph 11, so plainly on the paper.
What he says at the end of paragraph 34 is, from your point of view, a loose end.
Yes, it's
was still wrong. I mean, yes.
It's not there at all. It's not even that it's misnumbered and it's another paragraph. So. Whereas what is there at paragraph 15, i.e. the submission that the grant of humanitarian protection has not been challenged, is not addressed at all in the decision.
Hang on.
In paragraph 11, you do mention the qualification directive in regard to an old case, Forno.
Yes, which is about...
So there is some
But it's in relation
But
to
the
particular
confusing
social
thing is the
groups.
Proliferation Directive covers both the Refugee Convention and humanitarian protection.
Yes,
So that's neutral on this.
yes. It's really about what forms a particular social group. It doesn't go to the issue that the judge is raising. So, in any event,
I'm just wondering
yes.
whether. No, sorry, I've stopped wondering. Yeah, keep going.
I think really that's the last point I wanted to make in relation to ground 2. To summarise, was he entitled to consider that at all, and did he have a proper consideration of it? And in relation to the second point, I would say no, he doesn't address at all what the First Tier Tribunal judge found at paragraph 28, and he doesn't appear to address the arguments that were before him in the Upper Tier Tribunal on that point.
Well, hang on. Oh,
I thought you told him that, I'm looking at paragraph 15 of your skeleton for the UT. You're saying you can't go there because we've got the finding, the paragraph 28 finding.
Yes.
so
But I'm still a bit confused about, if I'm honest, is how you can say that the grant of humanitarian protection follows from a finding of risk of serious harm, which is what you seem to be saying at paragraph 15, because doesn't that just put in play whether there are mitigating measures that would protect you from serious harm?
Well, no, I mean, he could consider those issues in relation to the grant of refugee protection, but the judge had found that the appellant's account gave rise to a risk of serious harm. Risk of serious harm, just to go back to an obvious point, was not in any form challenged
but okay.
in the grounds of appeal.
But as Marie says, the question of the whole appeal would be pointless on questions of well, yes, I was just no, questions of internal relocation and sufficiency of state protection, which are just as relevant to humanitarian protection as they are to the Refugee Convention. If risk for the purpose of the humanitarian protection had already been conclusively decided and was not being challenged, nobody can have understood that to be the issue.
Well,
Might be the point.
one could have walked out of the Upper Tier
Sorry, say that
Tribunal.
again.
One could have walked out of the Upper Tier Tribunal with precisely that finding by the judge. Yes.
What finding? Exactly what finding?
Yes, there are errors of approach in relation to the Refugee Convention, but in any event, there was a finding of humanitarian protection. That's not been challenged, therefore, that's what remains.
Yes, but I'm coming to whether anybody can have thought it wasn't being challenged.
Well, it would have been, in my submission, put on a very different basis if that was still considered.
Well, would it?
to
I mean,
be-
you've gone into great detail on the question of sufficiency of protection
I didn't.
and on the question of internal relocation.
Yes, because those were under challenge.
Exactly.
And
But the reason you were doing that was because if there was sufficiency of protection, then you wouldn't have a claim for humanitarian protection.
no, because that could have solely related, that could either have solely related to the grant of refugee protection, or it could have been a discrete issue which the judge wanted further submissions on to confirm the judge the first tier judge's findings risk of serious harm. What's not addressed within that skeleton argument, except at paragraph 15, is the question of serious risk of harm.
Speaking for myself, I can understand your submission. I'm not saying I agree with it. But the question of whether there was a threat in the sense of people who might still want to do her damage had been precluded by the finding of para 28. You may be right, you may be wrong about that. We'll have to hear Ms. Jones. If you're right about that, the question of humanitarian protection would depend on sufficiency of protection or internal relocation.
And
But I
that was
can't
challenged,
believe
and-
everybody went through the whole of this hearing thinking it was an academic exercise because you were already entitled to humanitarian protection.
Isn't that exactly what the Secretary of State says on page 84 at G? They put in play, not solely in the context of the Refugee Convention, but as a much more generic proposition, the case on sufficiency of protection and internal relocation, saying the judge got those points wrong because they only looked at the expert evidence. So that whole mitigation of the risk was very much in play, and that's what the point was.
But that is mitigation of the risk.
But that's my lord's
but if-
point. That's exactly what we're saying.
But
If it's mitigated, then you don't not entitled to protection.
well, then you're not entitled to protection, precisely. But you have the serious risk plus the mitigation. Then you're not entitled to protection, but you still have the serious risk.
Yeah, all right.
But you don't get humanitarian. That's the point. Is you're
From-
wrong to
from-
say you don't get humanitarian protection if there is sufficiency of state protection and/or an internal relocation.
That is correct. Yes.
Or
So
maybe
there may
we
have been-
misunderstood. I've certainly understood a more modest argument that the question of a current threat was precluded by Paragraph 28. But I must say, I thought in the last few minutes you were going much further and saying the whole question of humanitarian protection was not in issue, and the whole appeal was an academic exercise. But maybe are you really going that far?
Yes, I think that could have been an outcome. One has to look back at it as it stood at that date. We had that finding by the first tier judge. It has not been open to challenge.
Yes,
I would
see
have
very
expected the judge to have dealt with that if he wanted to
It's
set
not just the
such a
evaluation
finding
of serious
harm.
harm, it's the acceptance that you're entitled to humanitarian protection that was beyond the scope of the UT's task, and it's accordingly beyond our scope.
UT was
That's-
only arguing about refugee convention.
Yes, I make the argument in the alternative, but yes, that would be
Okay.
my first argument.
Well, so your fallback argument is that
in any
in any event, the only live issues are internal relocation and sufficiency of protection, because the question of a threat was precluded by Para 28. That's your fallback position.
no, the fallback position is in any event, Deputy Upper Tribunal Judge Hanbury was wrong in his
No,
consideration.
that's your fallback position.
That's your next.
Right.
That's what you next fall back upon, is
Yes.
that if he was entitled to look at it, he got it wrong.
Yes, yes.
But because by the time he was looking at it, he was exercising his own judgment, not scrutinising the judgment of somebody else.
Yes. Yes, I think in terms of serious risk of harm, that is a separate question, to be clear, from the question of the mitigation of that risk and
Yes, it's what you've got to assess before you decide whether it can be mitigated.
Yes.
Okay, I will just write all this down. Right. Well, now we see the structure of your argument. I think the first two elements we've got, i.e., the issues he was entitled to decide. On the question of why his decision on them was wrong, if he was entitled to decide them at all, that's where we're going next.
Yes, I've said there was a marker there that Judge Holt had found. The appellant's account did give rise, in her view, to a serious risk of harm. And you can see she then goes on to deal in the next sentence with humanitarian protection. But I want to focus in terms of the marker purely on this question of serious risk of harm and how the judge should have dealt with that. I think that's best fed into my ground 3, which is the central challenge to findings of risk. Now, in the event the judge did accept that the findings of fact made in the First Tier Tribunal were preserved in his determination, and he didn't seek to move away from those. And I think it is worth pointing out what those are. They were that there was a risk from third parties who were customers to her husband and his brother's business, and that was a persistent risk which escalated into physical violence and then sexual violence in the form of rape. And there was repeated harassment and threats which led to attempts by the appellant, her husband, and his brother to move and escape that risk. And that both took the form of moving within Albania to different locations, and in terms of the brother, a move to Canada, in terms of her husband, a move abroad to Italy, and the fact that all of those attempts at relocation were unsuccessful. And when
you mean they were unsuccessful, there's no
Because the
suggestion. There's no
harassment-
suggestion that they were that the brother and the husband were not safe in Canada or Italy.
Certainly not with the brother. In the form of the husband, there was some evidence when he returned to Albania that the risk
Oh, I see, but not in Italy.
Yes, so it's the return.
Okay, sorry, I just wanted to make sure I'd understood
Sorry, I
correctly.
should have been clearer.
All the harm that happened prior to her leaving in December 2018 was in Albania.
Yes, and whenever she moved back to Albania, the threats to her persisted, and that attempt, or those attempts, such as they were unsuccessful attempts at internal relocation, and she'd also sought to obtain the protection of the Albanian police, and this had been unsuccessful. Now, first of all, the judge, or the high point of how the judge deals with that is at paragraph 35. It says the appellant has not received, and this is the second sentence there, it's the final part of that sentence. The appellant has not received any threats from any former customer of the business run by her former husband and her brother-in-law for many years, although incidents when she was there are detailed in the judge's decision. So it appears to be that his consideration of those findings of fact are encapsulated is in this final part of that sentence that detailed in the judge's decision. He doesn't recite those facts at all. A clue to why not can perhaps be found at paragraph 22 of his determination, where he lays out what he says is the factual basis of the appellant's claim. But given its length, shall I give you a moment to read?
Where am I looking at?
Paragraph 22, which is page 65.
Which bit of paragraph? Oh, I see. Yeah, okay. Yeah.
When he's referring to the earlier decision, he's referring to his own earlier decision, is he, or is he referring to the FTT's decision?
No, I think it must be a reference to the FTT decision. The point to be made there is that the essential parts of the appellant's claim, in my submission, the core parts of her claim are simply not reflected in that factual basis. So none of the threats made to the appellant herself appear there. The attempts or failed attempts to relocate on multiple occasions, both internally in Albania and externally, are not there. And the fact that she was pursued on return from those attempts to internally relocate, or in the places she sought to internally relocate to, the physical assault on the appellant and the fact that she was raped do not appear there at all.
I mean, slightly ineptly introduced, as it says, the factual basis for the appellant's claim is set out in the earlier decision. But in fact, it's really more just a summary of all sorts of facts about her case. It's not a summary of her claim to be at threat.
No, and it's not actually a summary of the parts of her claim that give rise to risk or grant
No,
of
quite.
asylum or humanitarian protection.
Not sure whether that point helps you or hinders you, but if this was intended to be a summary of why she was claiming she needed humanitarian protection, it clearly would be inadequate.
Yes. Just to finally summarise what also is missing from it, because it goes to the question of honour-based violence, is the fact that she was blamed by her mother-in-law for the rape, and it was reported to her husband, and she was told that this is why he had abandoned her.
Well, I've got muddled about that. The rape had nothing to do with honour-based violence. The rape was punishment or threat because of the husband not paying his debts.
Yes, yes.
There's no suggestion that she has suffered any violence as a rape victim
From
people who think she's been shamed by being raped, her family, effectively.
Yes, no. There's no suggestion of sexual violence from her family. It relates to
or sexual or violence. So honour-based violence, I understood to mean the woman has been shamed in some way, and therefore we will
protect our honour.
We will injure her in some way.
Yes.
There's
I
no
think the
evidence.
definition of honour-based violence relates to the fact that it is an attempt by a family or community to protect their honour through treatment
Right.
of the woman.
I'm just looking at the list that you take us to, paragraph 22,
Yes.
and the missing elements. I was just looking back at the error of law determination. If we were to go to paragraph 9, which is at page 61, one sees paragraph 9 reference to the treatment that she received being attacked, paragraph 9, and then one goes on to paragraph 19. We have at the bottom of that page a reference to the rape. And lack of protection. Your submission has to be, does it, that because the judge didn't mention it in his second judgment, he was not alive to the case that you were putting?
He didn't consider those factors adequately. He didn't consider the question of risk adequately. They certainly, they were all there within the First Tier Tribunal decision, and he retained those findings, and yet he doesn't recount them as core features of what he considers as a claim.
I mean, it's perfectly obvious, parking from the question whether he was entitled to do this, it's perfectly obvious what his reasoning was. His reasoning was, you that the claimant suffered, as he accepts, violence, including rape, from disgruntled customers of her husband in 2018. But there is no reason whatever to believe that going back to Albania 6 years later, that threat will still continue. Now, you may be right, you may be wrong, but you can't say he doesn't say what his reasons are, or take into account. It's not, or take into account the seriousness of the rape. In the sense, the seriousness is not relevant. It's the question of persistence that matters.
The judge has to give lawful and adequate reasons for his.
Sorry, I just can't hear.
The judge has to give lawfully adequate reasons to his consideration.
Yes, of course
risk.
he does. Yes.
The only factor, the high point on his consideration of risk, is what appears at paragraph 35 of his determination. And it can be summarised as the passage of time. Now, the passage of time, intervening period as he puts it, is a relevant factor. The defendant, Skeleton, says it's a relevant factor. We agree it's a relevant factor. But it is not the only factor in this case. He has to have in mind the other elements of the case which give rise to the claim for asylum and humanitarian protection. It appears...
But what other elements?
The elements I've just taken the court through, which is the seriousness of what happened to her in the past, so the need to examine her past persecution,
Yes.
her need to examine...
I accept that, but suppose he accepts that in full. That's the sense. I mean, sorry, in Cyprus say the rape isn't relevant, but the point is that these terrible things happened to her in the past. He accepts that. He doesn't have to write them all out. That's what the whole case is about. There's findings of them which he fully accepts. Next question, is there a risk that something similar will happen if she goes back 6 years later? That's the only question for him. That's the one which he decides that there isn't, and you have to challenge his reasoning on that. And to say he didn't say about the past events isn't really the point, because that wasn't what the issue was about. He was accepting the past events.
Well, I called into question if he was adequately accepting those past events. He doesn't include them in his factual basis for the claim at all. He certainly doesn't have any regard to them or mention of them at all in his reasoning on risk and return.
One point that I thought you made earlier was that you criticised the judge for the failings in reasoning, which is what you're dealing with now, contrasted with the First Tier Tribunal's approach. I read the First Tier Tribunal, and I give you the opportunity to deal with this, as really doing no more than finding the facts and saying this creates a risk,
Yes.
a severe risk. There's rather more in the Upper Tribunal's decision about the evaluation of what the present risk is than there was in the First Tier Tribunal, isn't there?
In terms of the issues of internal relocation and
No,
sufficiency
also in terms of persistence. I think the criticism which led to, one of the criticisms which led to permission being granted for appeal from the First Tier Tribunal was that the judge there had done no more than identify some facts and then say that's determinative. It's just that if there is anything more than FTT paragraph 28, which we've looked at a number of times, in relation to that judge's evaluation of risk, I'm not aware of what it is.
Yes.
She recites a number of serious issues, makes findings of fact, and then says that that leads to the necessary conclusion from your client's point of view. Do you say that her evaluation was more sophisticated than that?
In terms of the issues of sufficiency of protection, internal relocation, which
No,
was
that's not what I'm
no.
talking about. Now I'm talking about the existence of risk at the time of her judgment. As opposed to what happened historically.
Well, she's finding. I apologise if I've not understood your lordship. She's finding this account happened.
Yes.
The appellant fled Albania.
Yeah.
There is a serious risk to her on that basis.
Yes, I understand that, but she makes an evaluation of risk, which is no more than a statement that I find these facts, and that therefore establishes the risk.
Yes.
Now, I was picking up on the fact that you said that the reasoning of the FTT judge was to be preferred to that of the UT judge, which was deficient.
No, sorry.
You're not saying that?
No.
Right, well, I misunderstood that. Okay.
Yes.
All right.
I'm not saying that. I'm simply saying that the First Tier Tribunal judge accepted the facts as they were in the appellant's account, and Deputy Tribunal Judge Hanbury had to have proper regard to those facts. He is remaking here the question of risk, leaving aside how far he's entitled to do that. That's in
Yes.
ground two. He is doing it here. So this challenge is to whether he performs that exercise adequately. I don't seek to import.
No, the main point you've so far made about this is that he didn't even refer in his summary paragraph 22 to what was in some ways the most serious issue that your client was relying upon.
Yes, and that is stark within paragraph 35, where he simply makes reference to incidents when she was there are detailed in the judge's decision. A very unclear sentence, not one that is
Well,
easy
I think it's
to
perfectly
interpret.
clear. It might be regarded as a rather dismissive language,
Yes.
but it's perfectly clear. He is saying bad things happened to her in 2018 or 2017 and 2018 when she was last in Albania. So he's acknowledging that. You say, well, he should have spelt out what they were more, but he's making it perfectly clear he's aware of that. And he's saying, but nothing's happened. There's been no contact since. 6 years have passed. And especially when you read it with what he says earlier, it's hard to believe that the people who were willing to harm her then to get at her husband to get their money back would still be motivated to do so.
I mean, does he have those elements in mind?
Sorry, I'm getting deaf. You have to speak
Does
up.
he have those elements in mind? There's no evidence in the tribunal. Yes, they're recounted by myself, and he repeats my submission, but in his own preserved facts, the elements that would give rise to serious risk, whether for an asylum or humanitarian protection claim, are just completely there. So yes, he may identify another factor in paragraph 35, but we know from looking back at paragraph 22 what he thinks is the factual basis of the claim.
Look at paragraph 36. Second line. I do not accept the appellant would be at significant risk on return. The judge made no findings on her attempt to report matters to the police. So now, what was that about?
Well,
If not about the the physical and sexual assault upon her.
There was, I think the reporting to the police was a physical assault. But there's a different, it's not that he's unaware of those factors, but when we're dealing here with the question of serious risk, the judge has to be able to discern the basis of, or it should be discernible what the basis of the risk is. And that is simply not there, certainly not as a factor that he appears to take into consideration. The question about passage of time can only, and I'll move on to the content and the particular evidence in front of him about the passage of time, because we also say that that was inadequate. But that can only be addressed when one has in one's reasoning the fact that these were very serious events that happened to a person, events that, or he should have turned his mind to the question of, yes, are these past persecutory events? Are they events that gave rise to a risk of
He should have
serious
spelt them
harm?
out.
He has, in an asylum, in a protection claim, the risk of serious harm is a central question for the judge.
Of course.
And the elements that give rise to the serious risk of harm have to be central to that determination. On the risk of past persecution, there is no evidence at all that the judge had the persecutory elements in mind.
Well, except his reference to them.
An aside reference.
Well, right, but it's a reference. He didn't write that and not know what they were.
Well,
Your point is he didn't give lots of detail. And it's a perfectly good point, but don't overstate it.
no, but the point is that the First Tier Tribunal judge had considered those as giving rise to a risk of serious harm. Plainly, this judge doesn't.
Say that again, sorry?
Well, this judge doesn't.
No, well, he disagreed with her.
There's no even evidence that he disagrees that there's a risk of serious harm here on the past. He makes no findings at all about past
I
persecution.
don't understand what you mean on the past. He accepts the past events happened. The question for him was, does the fact that those past events happened mean there's still a risk if she's returned 5 years or 6 years later? That was the question for him. Now, I quite understand that you say that it would have been, that I'm not saying I accept it, but you're saying he in order to, as it were, set the scene, he ought to have set out fully what those past events were rather than just refer to them in this elusive way. But whether he did or not, what he then had to decide is, is there a real risk that similar events will happen if she's returned? And he did address.
I think he had to address his mind to the past events, not just that he knows what they are, but I think he had to come to a finding about whether they amounted to a persecutory or serious risk of past persecution.
I think it's obvious they do. I mean, what's more serious than rape?
It is obvious they do, but is it obvious in the judge's decision?
Well, of course.
He doesn't mention it within his findings.
Well, anyway, there we are. I mean, but nobody can looking at those events and think they were anything other than serious. And
I quite agree.
The question is, were they going to happen again?
In paragraph 46 of my skeleton, I just, there are two authorities, which unfortunately I didn't put in the bundle because it was accepted by the defendant about the proposition they represent. In asylum law, past experience of persecution is a material indicator of future risk.
Yes.
It isn't to say...
That all depends on there are other authorities, it all depends on the facts.
Yes, but it's not saying it is the determinative of future risk, but one has to make a finding on if past persecution happened to come to a proper consideration of future risk. I don't think it's self-evident that those facts, as the judge recounted them in paragraph 22, amounted to a proper consideration of past persecution, and therefore the risk of future persecution is flawed. No
doubt, because we've asked you a lot of questions about it. I think we now understand exactly what your point is on this. You have other points to make.
Well, I'll move on, if I may, to the points that I make in my skeleton argument about this question of the passage of time, because, as I've said, it is a relevant factor in considering risk, but was there an adequate consideration of it? I've laid out 4 factors there.
Whereabouts are you referring to in your skeleton?
It's paragraph 47 onwards, which is page 14 of the appellant's bundle.
Yes. Are you asking us would you like to reread those, or are you?
Well,
how
I
do you
highlight
do
them
the-
because it is particular in the circumstances of this case that passage of time was not simply something that was left in the past, that was not simply past events. The first of those is the repeated attempts to internally relocate and internationally relocate to escape risks from the ex-clients. At least that is an indication that those who posed the risk of serious harm to the appellant were persistent and were prepared to trace her. To be clear, I'm saying trace there, TRACE. She moved to various locations, both to the north to Tirana and to the south of Albania, and she was traced to those locations. Tracing in the country guidance on Albania, which I'll take the court to in a moment, is considered something that can occur because of the particular characteristics of Albania. It's a small country, and people tend to try and identify people through their connections to other people. Given that this was in the country guidance cases, given that there'd been previous and persistent attempts to internally relocate, could the judge simply say, well, we have a number of years since she left Albania and that is the end of the matter? He could have come to that conclusion, but I think those characteristics at least had to be in his mind for there to be an adequate conclusion on risk. The second of those is the expert evidence in the case, and that is about the features of Albanian cultural society that mean that a debt or an unclaimed, unfulfilled debt is not seen as something that ameliorates without some form of payback. It was the evidence of the expert, page 250 of the supplementary bundle, that suggests that the risks of the debt mean that the threats persist in this case, and they're unlikely to have been repaid. Again, that's a factor that tells against the passage of time. Thirdly, the appellant is in custody of 2 children from her marriage, and the third child, which at the time of appeal her husband's family were unaware of. This gives a particular persistence to the appellant's husband's family and to the husband to pursue the appellant. I've quoted there from KB, and that appears, in the authorities bundle.
So can we just be clear about this point you make elsewhere? You're relying on 2 separate threats.
Yes. One set of threats comes from those ex-customers of her husband.
And that's very firm. The past history of that is very firmly established by the accepted findings.
Yes.
But I think different questions arise about tracing by her family,
Yes.
which is on the basis of a quite different thread, that they
Yes.
will want to subject her to violence because she's had a child out of marriage.
Yes.
There are no preserved findings about that, are there?
Well, it's certainly not mentioned by the judge.
No, but they're none by the FTT.
No, the position was that at the time that the respondent wrote their refusal letter, the child who was born to a man out of wedlock was not born then, and it didn't feature in the refusal
Why is that
decision.
relevant at the time of the Secretary of State's decision? At the time of the FTT,
Yes,
the FTT decides it on the basis of
the evidence.
all the evidence before it, which would include events of which post-date the Secretary of State's decision.
Yes, I only say that because I think that may have shaped the submissions that were made by the
Well, I
presenting
dare say,
officer.
but again, it's not about criticising anyone. It's just about establishing what the factual basis is of the threat from the husband,
Yes,
or rather the husband's family. So we're in a completely different territory from what we've been looking at so far, where there are some preserved findings. There are no findings. So what is the evidence?
the evidence was from. Let me find the reference for you.
It's page 96.
Of the core.
Yes.
There are some general findings there about the patriarchal and nature of Albanian society and the threat of violence to women. But what I was meaning was, are there any findings that by the First Tier Tribunal judge, and I think you were accepting there weren't, that there was a real risk of violence against her on return by her husband's family because of her having a child by another man?
Yeah.
Maybe there are. I just
No, I think that's correct.
yeah.
There were no FTTJ findings on that point.
Yes, it seems to have only been put on looking at that decision.
So that's what you said about the Home Office presenting officer, that they adhered to the points that were made in the decision letter, and the decision letter predates the birth of the third child.
Yes.
But
So
this
to my
would have been
Lord's point,
sorry.
where is the evidence then? But what do we look at to see what her case was on family threats based on her?
It's both in the expert evidence and in the witness statement of the appellants, which appears in the supplementary bundle. So there is an expert report from Dr. Tahiraj, which appears at 236, and a section in that report at page 279 of the supplementary bundle deals with risk from her husband, which she says EL is expected.
Hang on 1 second. I just want to make a note. Yes.
EL is expecting a child from a man other than her husband while still being legally married to her husband. This is the greatest shame a married woman can cause to the husband and his family. Should EL be returned, she's at high risk of being harmed. Should her husband or any of his family members, including his brothers, decide to take revenge to restore the lost honour, such risk could also be pertinent to the youngest child as the fruit of her shameful action. And that comes against the backdrop of the experts laying out.
Yes, I mean that is a general statement that having a child out of wedlock is a matter of great shame. It's not.
It's
based,
not out
it's
of
not based
wedlock.
on any.
It's having a child to another man
So
while
sorry,
still
you're
married.
quite right. That is what I meant.
generic.
But
This is
my
generic.
point is that it's generic.
Yeah.
There's no evidence that the husband and father and brothers have in fact threatened any violence.
They don't know about the youngest child. The risk is that they will discover.
You don't know whether they know or not. There's no evidence about what they know about anything, is there?
Well, there's her witness statement.
Oh, well, okay, thank you. Let's do that.
I wondered why we weren't going to that first. Seeing
Yes,
as it's, what page?
Well, the witness statement's at 198
Page for this
of
reference.
the supplementary bundle.
Yes, what page is this matter dealt with?
Oh, sorry, let me just find that. First of all, page 210.
Thank you.
So you'll see at paragraph 79 to 81, she's had before this child was born, she'd had a termination of an earlier pregnancy, and she deals with that at paragraph 79, and then she's in a conversation with her mother-in-law, and she tells her that she had slept with another man and not got me pregnant. So it's not actually about this third child who's born, but it is similar when she's had a sexual relationship outside of her marriage, and her mother-in-law's response is contained at paragraph 81. Where she, in effect,
Top end is the mother saying, when your husband sees you, he'll kill you for everything you've done.
it's the mother-in-law. So there's been by an earlier rape, and she, in effect, shames her for the fact that she'd been raped, which is something that's commented upon in the country guidance and experts' reports about a feature of Albania's society where women are blamed, even when they're the ones who have been attacked. And she says that she told her husband about it, and that's why he'd abandoned her, and that when her husband sees me, he will kill me for everything I have done. And then at paragraph 130 of her witness statement, sorry, I would say 128, so this is page 218 of the bundle, and if one reads at paragraph 128 to 130, where she talks about the culture in Albania, the fact that she feels the police wouldn't protect her, she's an outcast from her own family, and she fears her husband and his family. And she says there, I worry about what they will do when they learn Noah was conceived from an affair and that Ertan is not his father. I am certain the authorities in Albania would not protect me at all if anything they would harm me. So that is the basis of why honour-based violence was put forward as a particular social group.
Thank you. Sorry, that was a digression, though a necessary one, from your skeleton argument, where you were dealing with the 4 reasons why you said the judge was wrong.
Well, I suppose that the point to be made there is that there were factors of this appeal which would tell against a simple passage of time being an end to the matter. The judge says, well, there's been no threats for years, it's been years, but it's been years that she's been out of Albania. The question is, what would happen when she returned to Albania?
Can we just, for our own clarity of thinking,
Yes,
distinguish the 2 threats?
yes.
Are you? Is there any more you want to say, either by reference to your skeleton or otherwise, about the passage of time as relevant to the threat from the husband's customers?
I think it'd be helpful if I pointed out what the expert says about those matters. If the court looks at page 245 of the supplementary bond.
This is threats from husband's creditors, is it?
Yes, yeah. And it's in a section on conflict resolution. Now, to be clear, of course,
Sorry,
this,
roll over to page 245.
yes,
Did you say this?
I think to be absolutely clear with the court, this isn't a blood feud case, and we don't put that on that basis. But there are features of Albanian society, as the expert identifies them, as they're identified in some of the country guidance. So there is a feature which the expert calls justification. And not turning to the authorities to dispute matters, which may be part of the factual nexus of giving rise to a blood feud, but may also have relevance in this case. So just to be absolutely clear about that. And at the bottom of 245, the expert says, equating the value of a person's life with the claim of taking back what is being stolen from them means that conflicts arising from such disputes are serious. Threats made in the name.
Sorry, which paragraph are we on?
The bottom paragraph of page.
Equating the value.
Yes.
Yeah, okay.
Threats made in the name of it are not to be dismissed. These conflicts do not fade with time. And she makes the point over the case that it can, over the page, that it can be difficult to separate the crimes of blood feud from those pure of criminal revenge. Now, the point I think that it relates to the appellant's case is that these debts that were owed by a husband and a brother, the reactions of those people who feel that they have owed money in that situation have been severe, and they have been persistent, and therefore they are borne out with what the expert tells us about how a debt is perceived in Albania. Now, the passage of time in that context, the expert says, well, it's irrelevant once that grievance is there. Now, the judge doesn't have to agree with that point of view, but if he's going to rely on passage of time as his sole reason, and we say it is his sole reason for finding there is no risk, there has to be a proper evaluation of what the passage of time means in the factual circumstances of the case. Yeah, so broadly speaking, for ease of the court, the points, the first and second points, which are made at paragraph 48 and then at 53, relate to
What?
48,
This is-
48 and 53, what, of your standard argument?
yes, at page 14. They relate to the risk of being a family member in refugee convention terms, or in terms of the factual basis of that risk. It is from those who feel they're owed money by the appellant's husband. And 3 and 4 relate more to the question of risk from the fact that she's had a child by a different man while she's still married. But as you'll see from 3, it's not a straight separation, because the fact that she has children, although that has a particular attraction to her husband's family, it also gives rise to risk to her, because the children are a way for her to be identified and traced. At the bottom of paragraph 54, I make reference to the case of KB, and if I could just take the court to that, because it deals with the question
Okay, take us to
of
it.
tracing. That appears in the authorities bundle at page 567.
Which volume of the authorities bundle is that?
I do apologise, mine are all in one bundle. I think it's the first
Sounds like
bundle.
left.
Yes, first bundle.
Yeah, I think it was in the second. Hang on, I'll just write on the back which pages are in which. Yeah. Which tab?
Internal page 567.
Okay, you haven't got tab. We haven't got tab numbers.
No. Oh, sorry.
It's just quicker to find. Don't worry, I find it now.
I can find it.
No, I've got it. I've got it.
Yes, you'll see this is a 2022 case from the Upper Tribunal, reference 00161. And it's not a country guidance case, but it mentions some of the country guidance cases that deal with this question of being able to trace family members in Albania.
Take us the paragraph you have in mind.
So
So
paragraph...
this is authority for the fact that you mustn't ascribe points to balance sheets.
No.
I mean,
Oh, sorry.
yes, I mean, I haven't seen this before, but I see somebody added somebody with balance sheet with points.
Yes, that goes towards article. Anyway, we'll come on to that if I may. But yes, it is about the approach under
But just take us the paragraph that you.
paragraph 30.
Yes, which paragraphs do you want us to read?
So it's the effectiveness of internal relocation to avoid a risk of harm from a non-state
Which paragraphs do
actor.
you want us to read?
Paragraph 32.
32.
There, the judge's
So
assessment.
should we just read it?
Yes.
Yes, thank you. So you say the same thing applies here.
Yes, the facts are very similar. Non-state actors, they are traceable. So clearly relevant to the question of whether the passage of time ameliorates a risk that exists in Albania. If persons are motivated to find the appellant, then she is traceable to them. And there's no basis to think that they wouldn't be motivated to do that, particularly where there are young children involved.
Okay.
The children, it's not a motivation, it's the way they would do it, isn't it? Because it's the registration point, isn't it? You say it's very easy to trace a mother with young children.
It is a motivation to her ex-husband and his family, because they are the two eldest children are his children.
Thank you.
I think that deals with ground 3, unless there's any questions outstanding from that. Ground 4 deals with sufficiency of protection, and there's two aspects to this ground. It's the fact that the appellant previously turned to state authorities and was unable to engage their protection. And then it is also about whether the judge's consideration of state protection was sufficient with regard to the individual circumstances of the appellant. If it's helpful to my lady and my lords, I can take you to the parts of her witness statement which deal with her engagements with the police.
Well, I mean, you've got to give the building bricks for any point you're going to make.
Okay.
I mean, I've looked at the witness statement, but I certainly recall when she went to the police there, it wasn't about the rape, was it? It was about an earlier incident.
Yes. Yes.
Anyway, let's well, show us what there is.
The reason I say it is because the judge,
Well, the judge accepted that this happened. If that's enough for you, that's fine. But if you want to show us the passages, I would stop you.
well, the judge says, well, that the first tier judge hadn't made findings of fact about it. But he says there is a reference in the original bundle. This is paragraph 36. The judge made no findings on her attempt to report matters to the police, but the appellant refers to her being turned away.
Where is this? Sorry, 36 of what?
The decision under appeal,
Number 2. So
page
number.
69 of the core bundle.
Got it, yeah.
Yes.
I don't think that fully identifies.
No, it's a reference. We obviously haven't got the bundle below, and I'm very glad we don't. But it's not actually a reference to her witness statement, which might be the obvious place to go to.
Yes, yes, and there was evidence in her witness statement.
That's what I thought you were going to take us to.
Yes, I was, but this is why I'm taking you there.
Yes, okay.
Because I don't think the judge has fully perhaps had regard
fine.
towards this evidence.
By all means. So which passages in the witness statement?
First of all, paragraph 54, which appears at 205.
What page again? I didn't hear you. Page
Paragraph 54 at 205.
205.
The supplementary bundle.
This is when she was living at home in Krukesh.
Yes, and then at paragraph 55 she goes on there. And then again at paragraph 217.
Hang on 1 second.
Sorry, page 217, paragraph
Yes.
121.
I'm just reading what you took us to first. I haven't got that. So this is a case where the police asked some questions, but don't do anything further, and she felt she wasn't taken seriously.
Yes, and then at 55 you can
Well, that's what I was.
see that she says it brought them more trouble.
Yeah. And then you were about to take her somewhere else.
Yes, then I was going to suggest page 217 at paragraph 121.
Well, that's a repetition of what we've already seen. It's this reference to the same incident, isn't it?
Yes, but yes, it is relevant. And then over the page, at page 128, again a mention that she was met with contempt and indifference, and nothing was done.
Thank you, yes.
So there is or it's clear from what is said there that they treated, or she was unable to engage their protection, and that's in accordance with the expert evidence in the appeal about the way the police deal with those who seek their protection. A past failure to be able to secure protection from the police is perhaps the best indication of whether a person will be able to secure their protection in the future. The judge's approach to it is at paragraph 36. Which is page 69, and his conclusion on the matter. Is the second to last sentence on the page. There is no reason to suppose that the appellant could not call on the help that is available from the police if she needs it. This will apply if former customers attempt to sue her on return to Albania, but seems unlikely given the passage of time. I suppose I make a rather obvious submission that the fact that they previously refused to help her is a reason. He identified a reason in the fact that she sought to engage them earlier and was unable to get protection from them at a point when the risks to her were escalating and before the more serious violence took place. And of course, it has to be at least suggested that the more serious violence, including the rape, could have been avoided if the police had reacted at this earlier stage. So that is at least a reason, and the fact that the judge says there's no reason to believe they won't help you in the future, it has to be wrong. In addition to that,
Was the judge shown the passage in the witness statement?
I'm unable to say if he was
No,
brought
fair
to
enough.
that
No, if you
particular
can't remember, that's fine.
passage. Now, the legal position in terms of the country guidance cases on sufficiency in protection in Albania is that in gender-related claims, at least, it's not enough to say that there is a Horvath standard. If there are particular personal circumstances of the person in question, then they must be considered when coming to a decision on sufficiency of protection. And that is, as I point out, paragraph 61 in my skeleton argument, consistent with Bagdanovicius in 2004.
So sorry, I was just making a note. Where in your skeleton argument?
Paragraph 61, page 16 of the 400. Now, what are the relevant personal circumstances? If one turns to page 307 of the authorities bundle.
307.
Yes. This is the case of CD and AD trafficked women 2016. It begins on page 264. But the paragraph I wanted to take the court's attention to appears.
So what is this? Is this a country guidance case?
This is a country guidance case. It relates
On trafficked women
in Albania.
from Albania. Or in
Yes.
Albania.
So
Okay.
not directly on point, but I think in terms of sufficiency of protection,
Yes, which paragraph did you say, sorry?
it's 119H, which appears at the bottom of page 307.
Yes, thank you.
Makes, I think, the established point that individual circumstances must be considered, and then highlights the social status, economic standing of her family, the level of education of the victim of trafficking or her family, the victim of trafficking state of health, particularly her mental health, the presence of an illegitimate child.
You don't have to read it all out. We read it. Yeah. Okay. Yeah.
I make the point that these are highlighted as the relevant personal circumstances, and a number of those are present in the appellant's case. I wouldn't say in her favour, but certainly as elements that give rise to the fact that she may need increased protection or be unable to obtain protection from the authorities, such as the fact that she's not in contact with her family, her state of health. She has mental health problems as laid out in the documents in the supplementary bundle, the presence of an illegitimate child, and what the fact that her family's from the north, which is more conservative. And the fact that she won't have a support network because she is ostracised both from her family and, of course, her husband's family there. So although that isn't country guidance for these circumstances, I would suggest that the judge at least had to have regard to the appellant's personal circumstances.
This authority was cited to him, was it?
Yes, it was. In fact, if one looks at the skeleton argument in front of the upper tribunal, so this is page 9 of the supplementary bundle, paragraph 22. Begins the paragraph where it says sufficiency of protection must be considered.
Yes, no, that's fine, I see. Thank you.
So there are at length set out their submissions about the personal circumstances of the appellant. So the judge didn't have to, of course, come to the same conclusion of those, but at least he had to have them in mind because of the authority of the tribunal and the higher courts, and they were all relevant to his decision. Again, then, his very brief consideration of the issues, where he says there's no reason to think that the police would not help her in the future, can't be sufficient when he hasn't at least had regard to her personal circumstances. In particular, when some of those are quite striking, such as the fact that she has her youngest child requires ongoing medical treatment, the fact that she has complex PTSD and anxiety, and that she will need to care for those children.
Speak up a bit, you're...
Sorry. And the fact that she will have to care for those children.
Right. So that's sufficiency of protection. Is that... What do you need to say about that?
Well, there was simply, I think, wanted to point this court to the experts' view on this matter that was in front of the judge, because I think it sums up well some of the barriers to accessing state protection, and it appears at page 269 of the supplementary bundle under the heading Barriers to Accessing State Protection. It's the paragraph that begins, the ability to access sufficiency of state protection depends greatly upon individual circumstances. Now, we've seen for this appellant the fact that when she sought to get the protection of the police, she wasn't listened to, and her gender was commented upon there, and perhaps this illustrates why those are important factors in trying to seek state protection. Who do the police listen to, essentially? And for this appellant, she has factors would make her unlikely to be able to access sufficiency of protection.
Very well.
Moving on to ground 5, the judge finds that Tirana is a reasonable flight alternative, paragraph 46.
Yeah.
And the first objection to that is that Tirana is not a place of internal relocation for this appellant. The judge appears to at least be aware of that factor. He says at the beginning of 46 that she claims to fear her husband's family, who is said to harbour resentment and is said to live in the Tirana area. And over the page, he comments at the bottom of that paragraph that Tirana is the scene of her husband's former business. I think it's useful to see that even the Secretary of State didn't consider Tirana to be a place of internal relocation. If one looks at the core bundle, where there is the defendant's original refusal letter, it states there at paragraph 117, which appears at page 123, that it says, based on your individual circumstances of your claim and the background information, you've not shown it be unreasonable to expect you to return to Vlor or Korçë or another location in Albania. So this is perhaps a further indicator of the lack of proper consideration of past risk.
What is referred to by another location?
Sorry.
What does another location
I suppose,
refer to?
I don't know. Anywhere else in Albania,
Than
I
what?
suggest.
Than what?
And what?
Anywhere else than where?
Oh, I would, well, Tirana.
Where is that?
Well, I think if we look at 105,
Yes.
the case that the Secretary of State is meeting is that you fear returning to Kukës and Tirana. So I think what 117 must mean is anywhere other than those two places.
Yes, yes.
Thank you.
This judge, however, considers that Tirana is a place of reasonable internal flight alternative. I would suggest that's further illustrative of the fact that he hasn't properly turned his mind back to the question of the events that took place in Albania that led to the appellant leaving the country.
I think those happened in Kukës, didn't they?
She was
Kukës
originated.
and Nange, which are close by.
Yes, she originated from Kukës.
Yes, but that's where the events happened, is my point.
Well, no, because by the time that the business was in Tirana.
I understand that. But
Yes.
but the threats, I thought, and the more than threats, the violence and ultimately the rape, took place, one in Kukes and the other in Nange. Am I not right?
Yes.
I mean, tell me if I'm wrong.
No, I think you're right. What happened was that the threat started actually in Tirana, and that led to the appellant, her husband and his brother all leaving Tirana because it was too dangerous. There were attempts to relocate, as you say, to Kukes and the village where her aunt lived just outside it. And there was the further serious acts of violence occurred in those two locations as well. So all of those 3 locations could be said to be the primary site of previous risk, i.e. they're not internal places where safe internal relocation could take place.
Yeah, but his basic point, as you say, is that she could go to Tirana and she would be safe there because it's big enough. And if necessary, she could go to a hostel.
This is what the judge says.
Is what the judge says, yes.
Yes. So,
and you're about to tell us why that's wrong.
yes, Tirana is wrong because it is the place where those who seek to cause harm to the appellant reside, and I say that on the basis both of the customers of her husband who first located them there, and second from her husband's family who were residing in Tirana. It is, in this case, the judge goes on to make comments about the fact that single mothers have problems in rural areas. So that is significant. If one can't be safe in Tirana, where is that? And one can't be safe.
Well, no, you don't have to meet a case that's not been put against you. The case is that you will be safe in Tirana.
Yes.
Yeah.
But
and you're saying that's wrong. Why are you saying it's wrong? You're just saying it's wrong because that's where the husband's business was.
Yes, and his
Therefore,
family.
it might be assumed that's where some of the customers are.
Yes. And the place where those threats started to them. It's also wrong because the basis in which the judge finds that Tirana is sufficiently large and populous for her to be safe there. I've already taken you to the paragraph of KM, but it's repeated in the country guidance case law. So in TD and
What is the point? Sorry, tell us the reference. I don't know what the point is you're about to make.
That it is not easy to be invisible in Tirana.
Yes, I see.
One can be traced by non-state actors there who are motivated to do so. Yes, I've already taken you to some of the evidence in that, such as TD and AD and AM, BM and KB, but just for completeness I refer to a case of BF, Tirana Gay Men Albania Country Guidance from 2019, which appears at page 419, where it is accepted that if one is motivated in Tirana, it's entirely plausible that a person may be traced via family or other connections.
Yeah.
So the judge makes this statement that Tirana is a large and populous city. It's around 500,000 people. He doesn't have any regard to the country guidance cases that suggest that, in fact, traceability is easy there. But of course, in this case, you're talking about a lone woman with 3 children. And the expert evidence was that that was very unusual in Albanian circumstances for women to live alone. And the fact that she has 3 children who will need to be registered with state authorities, who she'll need to seek healthcare to, will give her a level of visibility even beyond an average person who's at risk from a non-state actor. That is important. I've made reference in my skeleton argument to the case of VNM, which appears at page 104 of the authorities bundles, and there Lord Justice Wilson highlighted the fact that there would need to be consideration of her ability convincingly to present to those in her numerally a false history relating to herself and to her daughter, including the latter's paternity, and a false explanation for their arrival there, and in the light of her substantial psychological vulnerability.
Are you reading from something in VNM?
Yes,
Where
it's
are you?
It's paragraph 32 of your skeleton argument, isn't it?
it is, yes, it's
It's all
that
in there.
paragraph.
You're able to give me just a paragraph. I'm in the case now, so just to mark it up.
25.
Thank you very much.
I quoted that paragraph because, of course, there are striking similarities with the appellant situation, and of course the judge, if he's right, that return would be to Tirana. They would be in the city directly with their own
You
grandparents,
have the point,
which takes us to ground 6, which moves away from the risk issues. So I
Yes, I mean, by all means, I'd like to hear what you have to say about. Do you want to deal with particular social group first, or has that rather fallen into the background because of the other issues?
I don't think it has fallen into the background
But
because
because it's relevant to refugee. Do it as you like. I just wonder.
I think it was sensible to go back and deal with all of the refugee related.
Okay, so that means you will deal with PSG now.
Yes.
Yeah. Okay. I'm hoping we'll have to see. We're hoping you'll be able to be finished by lunchtime. I should mention now that we can't sit again till 2:15. If necessary, we'll sit a bit later in the afternoon to make up, but hopefully that won't be necessary. Okay.
Yes.
So ground 1, particular social group.
Yes, it's clear from skeleton arguments to the upper tribunal and repeated in the skeleton argument. In this course, there were 2 bases by which it was said the Refugee Convention was engaged: a member of a family and a woman at risk of honour-based violence from her husband.
Sorry, can you speak up?
As a woman at risk of honour-based violence from her husband and his family due to having a child by another man while married.
Yeah.
So that was the case on which it was said that a grant of asylum would be appropriate. So to be absolutely clear, it wasn't the submission wasn't made that all women in Albania formed a particular social
No, I didn't
group.
think it was.
It wasn't made on the basis of domestic violence. There had been none. It was not made on the basis of a blood feud.
I don't think the judge said any of those things, did he?
Well, it's very unclear in my submission what the judge does say. It's
Right,
entirely
fair enough. Okay.
contained at paragraph 33.
He
cites-
surely the last sentence in para 33. The rest is all just putting out of
Cases
disposing of points that aren't that you can't get home on.
that are not made. The relevance of citing DM and the trafficking cases and P is not clear at all. So the entirety of where he addresses the arguments that were put forward about particular social group are in that last sentence.
Yes, quite.
Could I just make sure we're absolutely clear about what your case was about this and what it still is, because I don't think it's changed. You say that you fall into 2 particular social groups. One as a member of an indebted family. That's the first one.
Not indebted. Oh, sorry. Yes.
As a member of a family with unpaid debts.
Well, as a member of a family. I stopped there because I don't think the second part is relevant to the.
Well, I'm looking at your skeleton argument in supplementary bundles 6, paragraph 5, in which you very crisply set out what your case is at paragraphs 5, 6, 7.
Hmm.
Right, a member of a family emanating from unpaid debts. I mean, I don't understand how you are a particular social group as a member of a family. It's because you're a member of an indebted family.
No, paragraph 6. Sorry, that was an attempt to explain the factual basis for it. But paragraph 6, this amounts to a claim for protection for a convention.
Yes, but in this case, it's not because you're a member of the Smith family. It's because you're a member of the Smith family that it has cheated customers.
No, I'll go on to explain why, but I
Right. So okay, well, it's your case. So I mean, it's you're saying it's because you're a member of a family.
yes, you're targeted.
Particular family?
Well, because she's targeted because because she is related to her husband.
To Mr. Crotty.
and to
So
her-
another way of putting it is because the social group is being the wife of Mr. Crotty.
yes, yes.
But it's not because he's Mr. Crotty. It's because he's a debtor.
I think not for the reasons that were given in fauna. That's why I
Okay,
say
well,
not.
perhaps you better show us for.
Okay, well, anyhow, that's the first one, that she's a member of a family.
Yes,
And the secondly is that she's a woman with a child born out of wedlock.
yes.
A married woman.
A
with
married woman with a child born to
born out of
another
wedlock.
man. Yes.
Right, so those are the two bases, and I'm sorry, while I was trying to work those out in my mind, you had been dealing with the treatment of these by the upper tribunal. And could you just give me the paragraph number so I can...
Yes, it's paragraph 33,
Thank
page
you.
69 of the core bundle.
Right.
So he makes reference to a number of cases but doesn't explain their relevance. And we say, to be clear, they're not relevant. And then the last sentence, he says, Miss Warren has not persuaded me that merely by being a member of her husband's family or associated with that family, this would be sufficient to make her a member of a particular social group. That is the extent we say of relevant reasoning about particular social group.
Yes.
Now, dealing with that family point first, it's clear from his error of law decision that he recognises that fauna is the most significant case, perhaps in
Take us to fauna then.
deciding. It's page 114 of the authorities bundle.
Just for another time, could we have much easier for us to have authorities in, so they look like the law reports, so they have a printed PDF, not this, whatever this odd format is. But don't worry, we'll work with what we've got.
What page were we at, did you
It'd be
say?
much easier while we're on it.
Yes.
We have bookmarked
Yes,
authorities. Because
I mean, the bundle authority has not been done properly. Was it done in your chambers?
No, it wasn't. No, but I'll
By your
pass. it.
solicitors?
Yes.
Well, I think they do need a bit of help because they haven't. We didn't have to. I've got my clerk to put tabs in. There aren't bookmarks in the electronic version. It's just not
Okay.
been done properly. But there we are.
So the page
we'll-
number
we'll
again,
cope.
please.
It begins on page 114.
1-1, thank you.
Yes.
4-9, yes.
And if one turns to page 125, Lord Bingham lays out the facts of the first appeal. So broadly speaking, this is the case of Kay, and she was a woman whose husband was imprisoned in Iran, but they were unable to say for what reason, and therefore whether it was for a convention reason.
Sorry, I've lost. Which paragraph of the Lord Bingham's speech?
The facts are, I'm attempting to summarise
For which oh, I see.
paragraph 2.
I see.
Would you prefer a moment to read those facts?
Yes, I'll just quickly read it. I think that's probably easier. Yes, thank you.
Yes, so the husband, as far as it could be ascertained, was not being persecuted for a convention reason, but his wife was. It was unanimous among the lords in fauna that this was irrelevant to the finding that the wife was entitled to protection from the Refugee Convention for her membership of a particular social group, and that particular social group was the family. And they go on to consider that. If I could just...
Could you take us to the passage where they say that?
Yes, it's page 132, paragraph page 132, paragraph 21. There, Lord Bingham was considering a case of a Court of Appeal Authority of Quijano and the Secretary of State for the Home Department from 1997. That case was disapproved of in K and Fauna. The facts of that case was that a stepfather had crossed a Colombian drug baron, not for a convention reason, and the Lords found this was not a bar to the appellant, who was his stepson, being part of a particular social group. And Lord Bingham comments on that at paragraph 21. The drug baron's persecution of the stepfather was plainly not for a convention reason, and he could not have claimed recognition as a refugee, but there was nothing in the facts as briefly reported to suggest that the real reason for the persecutory treatment of the appellant was anything other than his family relationship with his stepfather. That relationship may in one sense have been fortuitous and incidental, as Lord Justice Thorpe described it, but if it was the reason for the persecution he feared, it was in principle enough. So essentially, the family member or the family relationship which gives rise to the particular appellant's grant of protection because of their membership of that family, that person does not have to fall into a convention reason themselves. Lord Hope examines this principle at length in his speech.
What's the name of the case? In
the same case.
Same case.
Page?
Fauna. What page?
It's 139. It's the entire. Actually, if I take you to the previous page, 138, it deals entirely in that section with this proposition.
Family is a particular social group.
That's right, yes.
So he looks again at Mello and Quijano, and again he prefers what Mr. Justice Laws said
In Mello. I think it's significant what he says at paragraph, or the second half of paragraph 45, where he says the ties that bind members of a family together, whether by blood or marriage, define the group, and it's those ties that set it apart. And he then goes on to consider at paragraphs 47 and 48 the fact that it is unnecessary to show that other members of the group are under the same threat.
Okay.
So it is not suggested any other member of the family is at risk of being persecuted for reasons of membership of the family. The evidence of causation will need to be scrutinised very carefully, but the mere fact that no other member of the family is in that position is not determinative. So it matters not, I suggest, the reason why the husband is at risk and the fact that other family members are not at risk as long as the appellant is, because she is related to her husband.
But isn't, I mean, in paragraph 47, you may have just read this out, but in the middle of that, it's of course critical to identify what lies at the root of the threat of persecution.
Yes.
And I do follow that Kay says that it doesn't mean that in order to succeed, you have to show that every member of the family is at threat of persecution. But it seems when one looks at what Mr. Singh was submitting in that case, that there is an element of causation, isn't there? So in deciding what the group is, you also have to consider why that particular family is at a threat of persecution, because not all families are at risk of persecution.
I think he addresses this further at 48.
48, thank you.
And he says the
48 you just read out, wasn't it?
No, it was 47.
Oh, was it? Sorry.
The article draws attention to the position of the asylum seeker, not to that of any other person with whom he or she may be associated. It is his or her fear of persecution for a convention reason, not someone else's fear that is in issue. As Lawes J said in De Mello, the original evil that gives rise to persecution of the individual is one thing. If it's then transferred to that family member, so that family members are persecuted by reason of their membership of the same family, then on the face of it, that will come within the scope of the article. So I think, of course, he's saying there always needs to be careful examination in an asylum claim, but the fact that the family member is not targeted for a convention reason is not at the heart of that.
Yes, but I'm still, it probably doesn't make any difference in this case, but I'm still stuck at the idea that you can simply say that the PSG is a family, whereas in this case, your PSG
Yes.
is, your perfectly understandable PSG is as a member of a family that is indebted to dangerous people. I mean,
Well, that is why the risk arises, but I don't think in terms of the convention reason, I don't think that gives rise to the convention reason. I think that gives rise to the risk. Perhaps I could put it like that.
Well, it's hard to see how. Surely the reason for the persecution is part of the definition of the group, isn't it?
I would suggest not for the reasons that he gives.
Yes, I see.
At
Well,
20.
I think, speaking for myself, I want to look at this over the adjournment. Is that the heart of your point on this?
Yes, it may just be useful to read one other sentence from Lord Hope, because it may make it clearer why he says that. Persecution of a person simply because he's a member of the same family as someone else is arbitrary and capricious, and just as pernicious as persecution for reasons of race or religion. Yeah. So it's not a lessing because of the cause or otherwise of it. It's also worth noting what Lady Hell says at page 155 and at paragraph 105.
Well, let's just read that to ourselves. How is that relevant to the present point?
Because she's drawing that distinction between primary and secondary persons, and that is.
I thought she was saying that that's not a relevant distinction.
Yes, she's saying it's not a relevant distinction. I suppose, as she says, there's no warrant for that line of reasoning, and indeed.
Right, but
describes it sexist. I mention it because.
Well, I just think you risk confusing a straightforward point we've got from Lord Bingham and Lord Hope.
I raised it because of what the respondent said in their skeleton at paragraphs 27 to 29, where I think they do rely on that distinction. And I don't see how that stands with the reasoning in K and Fauna.
Very well.
So yes, it's membership of a family, we would say in this case. Going back to what the judge says, he's not persuaded, but he doesn't give us any reasons at all in paragraph 33. So in that sense, it's a straightforward reasons challenge under this ground. In that there's
And obviously, fauna was cited to him.
yes, it was cited, and he even mentions it in the error of law hearing.
Okay, well, don't worry about that. That's icing on the cake.
Yeah, but
The point is, it was cited to him.
yes. The second ground, the honour-based violence ground,
Okay, we only got a minute or two.
okay, I think I've mentioned probably most of this. He doesn't deal with this ground at all. It wasn't being suggested that it was win in its entirety that was in DM. I note that the defendant didn't rely on DM, which is domestic violence case, until this court, although they now say it's relevant country
Well, maybe
guidance.
that's a point for reply. But your point is that it was simply not dealt with.
It's not dealt with, no.
And you will tell us, I'm sure it's right, and if there's any doubt, we can look at your show as an argument that the same twofold basis was being put forward towards him.
Yes. Well, you have my submissions, I think, initially.
Well, that's a good place to stop, I think. We'll sit again at 2:15. You still need to deal with Article 8, which effectively means Rule 276 ADE, which again we haven't got, but perhaps you can bring a copy with you.
Yes.
Email
Email it.
You can email it.
So bringing is difficult.
Email it is fine. But we can't allow you much time this afternoon because we've got to hear from Ms. Jones.
Yes, of course.
But so you can be succinct in dealing with that.
Yes.
Thank you.
Court rise available.